how's everybody doing? We got a lot to get after, so just gonna get after it. My name's David Kerr. I'm principal of Cowrie LLC. It's a consulting company based around DAO issues. Started about a year ago when my entity structuring and tax consulting business was inundated with crypto issues. Once it took over 80% of the my client base, it just kind of made sense to commit fully to crypto. I'm also a research fellow at the DAO Research Collective. It's a organization funded by a number of DAOs to kind of bring forward the research in the space, to kind of provide material to builders, developers, users to help them kind of understand the space. Obviously, the disclaimer is kind of the same as everyone else's, not legal advice. Next slide, please. All right, so the purpose of this talk is to address DAO planning issues. And it was kind of highlighted around SEC issues and IRS issues, which we're going to do in a little different way than has been done. I saw some of the other slides. We all had the kind of the shared slide deck. And I didn't want to be redundant with what other people talked about, so I kind of want to build mostly on what you heard from Jeff, but obviously Yev and Jacqueline and Ross are doing amazing work as well. And we're going to try to integrate that so we don't repeat a lot of the topics. But instead of kind of laying out, the SEC tests around what is or is not a security, Reeves, Howie, Landreth, we're going to kind of talk about it a little more conversationally as it comes up in real time. So the three issues we're going to talk about are kind of common mistakes. I've been seeing how DAOs can position themselves for success, and then entity structuring, which is really my area of specialty. So we'll kind of hit that last. Next slide, please. All right, so the other presentations hit on a lot of the common mistakes. And so this was kind of one that I wanted to stress in particular, because it does really factor into the securities question, which is a huge part of DAO planning, especially given the ambiguity in the laws. And the kind of approach taken by the SEC to use enforcement actions to kind of regulate behavior of relatively high profile organizations and operations, instead of maybe going after the worst offenders. And so there's just a lot of ambiguity on what is a securities for purpose of tokens related to DAOs, governance tokens in particular. So one of the issues I've been seeing a lot is decentralizing too early. And so what I mean by this is there's a life cycle where the DAO is just an idea. It might be one person, it might be a group of people who are working on it, who are building smart contracts, who are developing, process of what their vision is. And one thing that has happened in this effort to kind of participate in the truly decentralized space is that group of people is sometimes releasing a token. They're sometimes, sharing governance tokens. They're kind of expanding beyond where they're at in the life cycle of the process. And there's a real benefit to waiting to become a DAO when you actually have, a viable community, a viable protocol. And there's no one rule, so this is more kind of a generalization that's just kind of been applicable for a lot of different situations. And that's quite frankly, if you have to do fundraising from a decentralized entity before you actually have, a viable community, viable token, then you're looking at a number of issues around having difficulty filing your taxes. You've certainly probably crossed some lines around your treatment of securities. And so this is something that you want to avoid. And the kind of the opposite side of the same coin is failing to decentralize, which is you have a community, you have a protocol, you have your smart contracts live, you've released a governance token and a treasury exists. But, if the people who are central to the DAO were to take a plane to the Bahamas and stay there, the DAO would stop functioning. That's just kind of a good test for the fact that you haven't reached, optimal levels of decentralization, both from a, an ethos standpoint, but also from a security standpoint. And so with that in mind, I think the reason for this confusion comes down to kind kind of a conflation of terms. There's been talk of a safe harbor, allowing DAOs to responsibly develop their decentralization. That has not actually become the rule. From a practical standpoint, it's almost unavoidable because immediate decentralization, like I said too early, or also in terms of just immediate, isn't really a viable structure for ideal operations when it comes to a DAO. And so, from that perspective, what you really want to be careful of if you're at a point where you're planning is not kind of confusing when you need to be decentralized and when you don't necessarily need to be decentralized. And so I think a big part of that kind of comes down to an SEC test called the Howey test, which is really focused around investment contracts and is not necessarily the most relevant SEC case law as it pertains to really scary DAO issues. Because when you look at Landreth, if you are a security, if you have voting rights, you have an expectation of profits, you have, meet those terms, then you are a security whether or not you're decentralized. Decentralization is not a secret sauce, special sauce that you just spread all over any project and make it not be a securities. It's a specific application of the investment contract principle and the test to make sure that you are not one. And so, from that perspective, decentralization is not a magic bullet. And so it really needs to be kind of captured as far as not just from a legal standpoint, why you want to be decentralized, but for the good of your project, understanding what your project is. So that's was kind of a non sequitur from the rest of the presentation, but it was just something that I thought was important from looking at the other slides to kind of emphasize. Positioning for success. When you do, start reaching out to counsel, to advisors. And I would recommend doing this sooner than you would think, like a lot of the folks said. There's a real shortage of practitioners in this space. And so getting on calendars, getting, consults done, forming relationships takes time. And if you wait till you actually need an attorney, you're gonna have some difficulty finding one right now because there is not a lot of availability in the market. But when I do consults, one of the first questions that I typically ask is why blockchain? What's the purpose of your project that is getting value from the blockchain, that is getting functionality from the blockchain? A lot of the concepts that I hear are, quite frankly, not in line with what you would consider to be the most optimal uses for a DAO, and certainly not the most aspirational for what DAOs can be. If you're just trying to find easy ways to skirt security laws, there's easier ways to do it. And there's also easier forms of governance than decentralization. So it's a real commitment. And so to kind of enter into the space just because it's kind of the buzziest place right now is a very common problem that we're all facing. And it creates just an enormous amount of problems if you can't define what it is about your project that requires the blockchain, what value you get from it, what benefits you get from it, what functionality you get from it, and what you see as the future. Jacqueline just mentioned revenue, profit, and distributions as something as part of her client intake. I think it's part of every client intake. I mean, this is the question that you need to have answered because so many of this colors what we have to deal with in terms of complexity down the road. I'll skip to distributions just because, member distributions is the easiest way to fall afoul of Landreth. If you have an expectation of deriving profit, from the holding of a governance token, you're not really credible in the sense that it wasn't a security. And so having a member distribution plan baked into your approach for what you want to get out of a DAO, having a relationship with a centralized body who has control over the DAO. These are real fundamental problems that are going to, be the death knell of your project, quite frankly. Like, some of these things can't be overcome. And so having an understanding of how your protocol, how your DAO is going to generate income, what the profits are going to be, what you're going to do with those profits is absolutely essential for any of the decisions around tax planning, entity structuring, legal protections, and then also just operational functionality for yourselves. And so that's kind of what comes down to clarity of vision, is that to be able to articulate all this is hugely important, and not in the form of a white paper that kind of aspirationally talks about what's in smart contracts and might exaggerate a little, but I mean clarity of vision in the sense of what your actual purpose is, what your value is. A lot of the ideas in this space are more redundant than I think people think. It's one thing to have a good idea about what you can use the blockchain for. It's another to ask yourself and ask your community, are you the person? Are you the people who are best situated to develop this? Do you have the funding? Do you have the knowledge? Do you have the expertise? Because someone else is thinking of the same thing you are. There's not all that many practical applications that exist at this level of the Web3 development. Now, in the future, I think it's going to expand. I'm a believer in the space, and I think we need trial and error. So that's not a judgment of, the long-term viability, but at the same time, a lot of the projects have some pretty similar themes once you kind of break apart, native to protocol, investment DAOs, once you start kind of subsetting, wanting to hold real property, wanting to have, sponsorship relationships, and then obviously some of the work that's absolutely fantastic is taking away the more obscure and time-consuming in-person requirements for financial transactions, which is wonderful. But again, once that idea is out there, you don't necessarily own it. So clear vision of what you actually intend to do with your DAO is, an extraordinarily essential part of what we're about to talk about, which is the planning around some of the law requirements, some of the tax requirements, and some of the available entity structures. Next slide, please. Okay, so this is a big one. Crypto Twitter is an interesting way to spend half an hour of your day. I joined about 4 months ago, and I haven't found it to be additive to my life quality, but important for work, so we do it. But one of the debates that is thriving in the space is what it should mean to be a DAO, what the definition of a DAO is. We saw all the panels yesterday had their definition of a DAO. And, in spirit, I was in agreement with all of them, but they weren't all the same either. And so, there's this kind of desire to have a purity test of being a true DAO, or the DAOiest DAO, the most DAO. And the reality is, once you start crossing the land of entity structuring, and you're past the point that and a lot of people do believe this, a lot of very smart people believe that a true DAO in and of itself would not have a legal entity structure, that it wouldn't have to file taxes, that it would exist in a place in cyberspace that would be free of jurisdictional tax requirements, then in a lot of ways would be free of the law. It's a valid point. It's not one that I personally hold for myself, but we all, the people in the space who specialize, disagree with some of those concepts. But what's not up for argument is that's a subjective debate over what a DAO should be. And for its existence in the real world, for treatment in the real world, for treatment under the law, for treatment for taxes, we need to ask the other questions, the objective questions. What does your DAO do? Where does it do it? And who actually does it? Because it's the physical location, it's the activity, it's the citizenship, it's the geographical overlay, it's where income streams come from, it's how income streams are generated that define a lot of this. And so simply saying it exists in the cyberspace when there are physical components in the real world or citizenship-based requirements through law, because the fact of the matter is physical nexus has been on its way out of taxation for the past 15 years. The work that's being done at the OECD on that front, the overturning of Quill, which was a longstanding Supreme Court case that required physical nexus for the purpose of collecting sales tax. Wayfair trumped that and said physical nexus was not a requirement. But that wasn't just a sales tax case. I mean, that's how it was talked about. But that's really opening up the door for the idea that you can tax income without a physical nexus, which for the history of taxation is a mind-blowing concept, but that is the future we're looking at. And once states start figuring out how to tax at that level, finding a viable economic argument for why they have a right to the income, there's going to be state tax problems across the board, not just for DAOs, but for a number of internet-based companies and entities, because right now there's no state tax being collected in that way. And so the future of tax is scary. And the objective point is kind of important information for making a determination around entity structure, how to meet that obligation, because down the road, the law can always change, and I certainly understand the arguments that the blockchain is certainly a pretty good impetus for unfair enforcement and can certainly put up obstacles. But at the end of the day, the internet is a copper fiber that runs under the ground, connected through the ocean, and ham radio. And there are physical restrictions on it that we don't necessarily think about when we think about the internet as an amorphous, ethereal kind of everywhere. It's tangible, and governments have claim to it, and that's a reality we kind of have to live in. Next slide, please. Okay, so then the right tool for the right job. When you've made this decision to start looking at your legal entity structure, but you have to realize DAOs are not a legal entity. That's part of why the subjective definition of DAOs doesn't really matter that much. You can call it a DAO, you can call it whatever else you want to call it. It's substance over form that dictates this relationship. So, as a tool to bring individuals together for a common purpose, that's a general definition I think we can all accept. It's not, very detailed, but it's just kind of general. But it's the nature of the relationship that might have a real world impact, could result in default legal structure being applied, default entity structure being applied. And in this way, I am talking about US, but it is also worth pointing out that it's very hard to avoid the US when we start talking about these discussions. To be truly free of US citizenship involvement in your DAO is a very difficult process to pull off. It's a technical process, it's a commitment, and it's also a strategical decision to eliminate what is currently probably the most viable funding source, participation source for members. And so that relationship brings the US into the equation, both from a US security standpoint, which gets their jurisdiction simply from a US citizen holding or being able to hold a security, or potential security, make the evaluation. And the IRS that has a number of US-sourced income, effectively connected income requirements that can make what looks like international income, quite frankly, much more tied to the US than we necessarily want it to be. Next slide, please. Same kind of general concept. Legal entities are not tax entities. Legal entities, and this is, I think, a confusion that happens because C Corps are taxed at a certain rate of transaction. C Corps have corporate tax, and there's kind of a parallel. But taxable entity structure actually sits on top of your legal entity structure. And so some of the entity options actually have a choice in taxation, others don't, like the C Corp. Next slide, please. Okay. So the bottom line is that all this complexity intersects around DAOs, and it needs to be planned for before selecting an entity structure, because this all has kind of a finishing point, like how the tax intersects with the legal, that intersects with the filing requirements. And when I say filing requirements, some of these filing requirements are set up with punitive penalties. So it's worse than not paying tax, not making your reporting requirements around having activity in a certain location. If you fail to do that, some of those penalties are upwards of $5 million per offense. And so we're dealing with a situation where ignoring some of the requirements for doing business in the real world, or operating in the real world is a better way of putting it, that there's an obligation that people could be held accountable for, whether it flows all the way up to the members through an enforced general partnership or they've elected an entity structure. There's no real easy way to avoid some of these requirements. And right now, the reason why we have is that enforcement has been so slow that we almost feel like it's not coming, because it's just an amazing backlog on actually having the government catch up to the technology because it's developing so fast. Next slide, please. Next slide, please. Okay, so this is my background. I published a paper with Miles Jennings. He's the A16Z General Counsel a few months back. It was on legal structuring. If you haven't read it, there's a lot of background on what I've talked about in much more detail. The securities cuff's covered more detail. I'm also happy to answer questions through email, provide some reading, because I know we're going to be a little short on time here. But what Miles and I are working on right now is part 2. And part 2 is going to be released hopefully in the next 2 weeks, no later than the next 3. And it's going to be organizational forms. It's going to be form articles of organization, highlighted issues. It's going to be an explanation of, entity type, these considerations. Next slide, please. And we basically walk these items across all of the entity structures. So there's going to be one for the Guernsey trust structure. There's going to be co-ops. There's going to be Wyoming DAO law, the LLCs, obviously the UNA, the Cayman and the Panama structuring. And after tomorrow, I think we're going to look at the Marshall Plan that was kind of discussed in the morning and kind of talk about it. And if you go to the next slide, And so this chart's actually done. I just didn't want to spoil the reveal when we're done. It's being tweaked, and so I didn't want to be held to it. Obviously, I'm comfortable with the UNA, but we need to kind of fill out the rest of it. But so what Miles and I are looking to do is kind of give DAOs who are starting out a clean path to what they need to decide on, what they need to consider, and then what entity structures actually jump out as preferable given their facts. And so this whole everything's different, there's so much complexity, that's still gonna be true, and you're still gonna need a lawyer. But we're hoping to kind of move the conversation forward for why you might consider different things. And I know I'm out of time, so one real fast example would be, if you're looking at an investment club, that makes a lot of sense to be the Wyoming DAO, or at the very least Delaware LLC. That would make no sense as an UNA. And so we have to really look at, do you plan on holding real property? Do you plan on having events in America? Do you have planning on events in person anywhere? Where do your people work? How do they work? Do you have employees? All of these questions need to get answered so we can have a better idea of what we're actually advising on around entity structures. It's coming out in 2 weeks, maybe 3. And thank you for the time.